Well, good morning and thank you for joining us, whether you're watching live or joining the recorded session at a later time. My name is Michael Gault. I'm an eminent domain attorney with Bell, Carrington, Price, and Gregg, and I want to thank you for being here. At the outset, let me just say, because I'm required to, that this town hall or any town hall that we do is not meant to provide any legal advice. Instead, we're here just to provide some general information about the project to you and about eminent domain in general. And if you have any further questions or concerns, we're going to provide you with some contact information later on in this session. We invite you to reach out to us directly. And at that time, then we can begin to work on some more detailed information on a parcel by parcel basis and hopefully establish that attorney-client relationship that will allow me to provide real legal advice to you. So let's get started. If you're here today, or if you're watching this, you know that we're here to talk about an I-26 project. It's the I-26 widening project between mile markers 125 and 136. This particular project is part of a larger goal by the SCDOT through an overarching project known as the Midlands Connect project. If you've been up and down 26, I guess east to west on 26 lately, you know that construction's everywhere. And so this is part of that bigger goal, that bigger project by the SCDOT. Along this particular stretch between 125 and 136, there will be a number of impacts to many of you that are landowners along this stretch. But there are two intersections in particular that we show that will be more heavily impacted than others. Those are the intersections with I-26 and Highway 21 and Highway 6, or the Caw Highway. At those two intersections, there will be massive redesign, changes of the on-ramps and off-ramps, and those intersections will just be greatly impacted, and many of the landowners and the parcels at those intersections will be more heavily impacted than others. Naturally, if you own property that is adjacent to an intersection with an interstate on-ramp or interstate off-ramp, and you have frontage on a major interstate, there's a good chance that that property is more valuable than most, potentially commercial or industrial type property. And so if those parcels are impacted, then the value of the impact is often felt greater by those landowners than someone who's miles off of the interstate in this particular part of the state, in a more rural area with less commercial or industrial development. So why should you be concerned? As a landowner, if you're impacted by this project, the reason you're going to be impacted is because the DOT will need to take part of your land through a theory called eminent domain in order to make these changes to the intersections and to the 26 widening corridor. Eminent domain, it's a legal term that basically means that the government has the legal ability to take private property for a public purpose. In a case like this, the public purpose is probably going to be met. The courts will probably say that the DOT will have the right to take the property, but that doesn't mean that you don't have rights as a landowner. Among the most important of those rights that you have as a landowner is that of just compensation. So, even though the DOT can likely come in through this project and say, hey, here's what we need, and this is how we're going to take it, they have to compensate you fairly and adequately for that. And that process can be complicated. And that's sort of where we come in. At Bell Carrington, we have experience in eminent domain matters. We work on these cases every day. And so we know the process and procedure. We know the language and the terminology. And we can help you through a project like this when oftentimes if a landowner tries to handle these cases by themselves, they're met with a process that they don't understand, that have never encountered before, and terminology that they may have never heard. And so that can be overwhelming. It can be confusing. And so we like to help our clients through this process, to guide you through it, to make sure that we're not missing anything, that the DOT is not missing anything, and that ultimately your rights are protected at the end of the day, and that just compensation, which is what you're seeking, is what you gain at the end of the day. Each parcel that's impacted on this project is impacted in a different way. I can't sit here in a generalized forum like this and speak to each of those individual impacts, but I can tell you this. At Bell Carrington, we're fortunate enough to have some proprietary software that will allow me to, while I'm on the phone with you in real time during our initial consultation, to be able to pull up your individual parcel and tell you what we show the impact to be pretty quickly, while we're in that consultation, so that we can have a serious and intelligent conversation about how you may be impacted and how we may be able to help. The good news about those consultations at Bell Carrington anyway is that any eminent domain consultation, initial consultation, is always free. There are no consultation fees associated with that. We have a team standing by ready to speak with you individually to dive more into the details of your impact and to find out how we can help you, and there's no cost ever for that. The second thing, and I believe this is important just because of the general stigma behind lawyers and lawyer fees, is that in eminent domain cases at Bell Carrington, we'll never charge any upfront or out-of-pocket retainer cost or attorney's fees. There'll never be any out-of-pocket cost to you as a client of Bell Carrington in an eminent domain case. Instead, we operate on what's known as a contingency fee basis, and that is a big term for basically saying that our fee is a percentage of the ultimate recovery, be that through settlement of the case or ultimately in the trial of the case. We can dive into those fee arrangements and fee agreements more on a case-by-case basis or on a parcel-by-parcel basis. And so over in the chat box or in the description of this video, you will see a contact number and an email address. Feel free to reach out to those contact informations, the number and the email address. They come to me directly, and we have a team. If I'm not able to reach you immediately, somebody else will, so that we can talk about the potential impact to your property, if there is one. If not, great. That's better news for you as a landowner. But if you're impacted, we need to see how you're impacted. We need to make sure that we fully flesh out that impact and make sure that you're protected throughout this process from beginning to end. The reason that we're having this town hall now is that we've been contacted recently, and we know that right-of-way acquisition is kicking off. Folks are starting to be contacted by DOT representatives regarding the acquisition on this project, and so now's the time to act. Again, let me finish by saying that nothing that we've said here is intended to constitute legal advice, just general information about the project and eminent domain in general. But we are happy to speak with you more on a one-on-one basis to provide some potential legal advice and to hopefully help you with this project. Again, Michael Gault with Bell Carrington, we want to thank you for joining us today. I look forward to speaking and hopefully working with some of you more in the future. Thank you.